Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome back to Win with the Law. Today, we have a very special guest. And as you know, we bring some of the profession's most prestigious attorneys to you so you can learn about the law and current issues in the law and how it affects your life. Today, we have Mary Pat Donohue, and she's going to share with us the workers' compensation system. She has been practicing in work comp law for, I'm not going to say how many years, and she knows the law. She knows the law, the work comp law better than anyone. Mary Pat, welcome. Can you tell us a little bit about your background?
Yes, I've been practicing in workers' compensation over 30 years. I graduated from Loyola University School of Law here in Chicago, and I started out as an assistant state's attorney. I did criminal appeals first. So I argued in front of the Illinois Appellate Court and the Illinois Supreme Court while I was a state's attorney, and I also did some jury trials. After that, I had the opportunity to work for both Travelers and Hartford's in-house counsel legal departments, and I did workers' compensation litigation for them, although at that time I defended employers. For the last 6.5 years, I've been here at Newland and Newland, and now I represent injured workers.
Sure. Now, with respect to work comp, you obviously have extensive experience, and I'm wondering if you could summarize what the work comp system is.
So workers' compensation has been set up to help workers who have been injured on the job receive earnings while they're off of work, medically authorized off of work as quickly as possible, to get them their medical treatment as quickly as possible, and to get them back to work as quickly as possible. Here in Illinois, it's a remedial system. The hearings are handled by arbitrators, and the Illinois Workers' Compensation oversees the entire system. The accidents involved are accidents on perhaps an employer's job site or an off-site job site that an employee's been assigned to. Sometimes when an employee is traveling and they're injured, if it's for a work purpose, they're eligible for workers' compensation benefits. And the type of accidents that can be covered are lifting, repetitive trauma. It can sometimes be something falling on them or they're falling. So it covers a wide variety of accidents at a lot of accident sites, and it involves a lot of injuries too, different kinds of medical conditions such as carpal tunnel syndrome, herniated discs, fractures, things of that nature.
Now,
we differ very much from.
Please finish.
What I was going to say is workers' compensation is a very different system than personal injury. Personal injury cases are handled by, in litigation, by a judge or a jury, and their awards can really vary in amount. However, in workers' compensation, it's more of a calculation, and it's very much controlled by the Illinois Workers' Compensation Act and decisions from the Illinois Workers' Compensation Commission.
Interesting. Now, what I tell people when it comes to work injuries is I tell them that, the law wasn't created to protect the employee, it was created to protect the employer. And is it fair to say, I think the workers' compensation system evolved because employers didn't want to be taken to court. They wanted to have more certainty in what they'd have to pay their employees if they were injured. Is that
yes,
fair?
I would agree. On the employee side, there's a lower burden of proof than they may have otherwise. because they only have to show that some aspect of work was a cause of their injury. The employers the employers give up a lot of defenses that they might have in civil litigation, but the system is designed to give the employees some kind of compensation while they're off of work and they're in need of medical treatment. But it also very much protects employers from having to go out of business if their exposure was not capped through workers' compensation laws.
It's interesting. So, does workers' compensation insurance pay doctors what they charge, or is there some sort of discount that they get?
So in Illinois, the Workers' Compensation Act states that the Illinois Workers' Compensation Commission will set the amount that doctors and hospitals and different medical providers can charge. So a lot of times the bills come in, they're very large, but they are capped actually by the Illinois Workers' Compensation Commission.
How does an employee that's injured on the job, whether it's an occupational disease or a physical trauma, how do they file a workers' compensation case?
Okay, well, first of all, if somebody has an on-the-job accident or injury, they really need to go to their employer right away and give them notice of what happened, how it happened, and when it happened. And then after that, they need to see a workers' compensation attorney. Not all attorneys handle workers' compensation, so you really need to get an attorney who handles it, because workers' compensation is very, very specialized. It's just a very specific type of litigation. And then once their case is filed, if the employer accepts what happened to them, accepts the fact that they're entitled to benefits, then right away, presumably they'll get their money while they're get some compensation while they're medically authorized off of work. They'll get medical treatment, and presumably they'll get assistance in getting back to work. If the employer does not accept that the accident is eligible for workers' compensation benefits, at that point, the case would probably have to be litigated, and it would need a hearing in front of an arbitrator and possibly an appeal in front of the commission, which is 3 commissioners that hear the appeal.
I was trying to think, one of the major defenses in work comp that employees should be concerned about is what's called a pre-existing condition, right? And how does pre-existing conditions, how do they impact an injured worker?
An injured worker can have a pre-existing condition, and the injured worker can also actually have a pre-existing condition that's aggravated on the job. So normal degenerative processes might not be considered eligible for workers' compensation benefits. However, if something happens, some sort of cause on the job aggravated or accelerated the pre-existing condition, then the employee is potentially eligible for benefits.
So with respect to that, does an employer has a choice? They can try and argue that the pre-existing condition is really what the injury is, that it really didn't take place at work. Is that sometimes their defense?
Right. The employer will always argue that it was pre-existing and unrelated to what happened at work, but the employee need only show that something happened at work that was a cause of an aggravation or an acceleration of the condition. And that puts them in the realm of being eligible for benefits. For example, a lot of people have osteoarthritis in their knees. If they fall at work and it causes an aggravation or an acceleration of knee problems requiring maybe arthroscopic surgery and later a total knee replacement, they're eligible at that point for workers' compensation benefits.
Now, to maximize their benefits, there's a difference between a temporary aggravation and a permanent aggravation to a pre-existing condition. Can you explain to the listeners the difference between the two?
Temporary aggravation might be something like a contusion or a temporary sprain. It doesn't really change the nature of the degeneration, perhaps in the knee, but when there's an aggravation or an acceleration, you're talking about a major change in the condition of the knee or whatever body part. If there's never been a recommendation for surgery before the work accident, and then now there is a recommendation for the surgery, that would be indicative of the commission possibly finding that there's an aggravation or an acceleration caused by the job and what happened on the job, whatever the accident was.
But ultimately, there needs to be a medical opinion to opine that the pre-existing condition was permanently aggravated to optimize the recovery, correct?
Right. So in workers' compensation, the commission and the arbitrators are very sympathetic and they listen very carefully to what employees say, but they also place a great deal of weight on written medical records from the doctors and the doctors' opinions. So when employees go to their medical providers, it's very important that they tell the medical provider everything that happened and how the work accident impacted the body part involved, so that there's that causal connection between what happened at work and how that accident impacted and injured the body part. So written medical opinions are very important.
What type of benefits is an employee entitled to if they get injured at work?
So when an employee is medically authorized off of work, or the doctor gives them work restrictions, which the employer cannot accommodate, they're entitled to something called temporary total disability. We call it TTD, but it's like a weekly workers' compensation disability check that they should get while they're off work. And it's 2/3 their average weekly wage being the average they made for the 52 weeks before their accident. So for example, if somebody makes $800 a week, average weekly wage, they should get 2/3 of that every week in a workers' comp check, and that would be about $533. So that's how that works.
So that's every week while they're off.
Correct.
And they need to be permitted off by a physician. Is that
Yes,
also?
they have to have a written medical note, and they always have to give that to their employer right away, and they should give it to their workers' compensation attorney right away, because that helps keep the benefits going more smoothly. They also should get authorization for whatever medical treatment they might need. And at the conclusion of their case, when they're as recovered as much as they're going to be, which we call maximum medical improvement, they're entitled to a permanency award, which we call permanent partial disability, PPD. And that's where you get into the very close calculations of what a workers' compensation injury is worth. And permanent partial disability awards are based on the PPD rate, which is 60% of someone's average weekly wage. So for someone who makes $800 a week, 60% of that is $480. So that becomes their PPD rate, $480. And Illinois state law has set it up that, and that's the Illinois Workers' Compensation Act. They've set it up that every percentage of the body that is impacted by an injury has so many weeks of permanent partial disability. So you take those weeks times somebody's PPD rate, and that's how you determine the value of an injury. So we're very different than personal injury. Personal injury has more variations to what somebody might get. In workers' compensation, it's a calculation, and the employee's ultimate recovery is going to be based on what their average weekly wage is. So someone who makes a little less may recover a little less. Somebody who makes a little more may recover a little more, but it's a consistent valuation under the Workers' Compensation Act and according to commission decisions.
Are different parts of the body worth different amounts of money?
Yes, because we have something that's called the disability conversion table. It's like a slide rule. And this follows what the Illinois Supreme Court, or excuse me, the Illinois Workers' Compensation Act says about what injuries are worth and what the commission says. So for example, if somebody injures their hand and they have surgery, they may get 25% of a hand, because that's usually the range the commission gives. You take that 25% of a hand, that might be worth about 30 weeks compensation. So you would take 30 weeks times $480 PPD rate, and that's how you determine the value of an injury. If somebody has an amputation, God forbid, 100% loss of an amputated leg, when you talk about that kind of injury, you're talking about 215 weeks times the PPD rate of $480. And that's how we determine the value of injuries. The commission has seen every single kind of accident imaginable and every single kind of injury. They give the range of the values, and then the Illinois Workers' Compensation Act determines the number of weeks of compensation for the injury according to the percentage loss of the body part.
The lawyers look at precedent to see what the commission has awarded. Like, for example, let's talk about carpal tunnel syndrome. If someone is diagnosed, let's say, with carpal tunnel syndrome in their right hand, does it matter if it's the dominant hand?
No, it doesn't. And again, the commission decisions give you the range of value. So for carpal tunnel syndrome with a carpal tunnel release surgery, they'd probably evaluate it at 25% loss of the hand. So they always give you the range of value. If it's only a hand strain or sprain, maybe they'd only get 5% loss. If they perhaps fracture their hand and need multiple surgeries, perhaps they get 60% loss of the hand. If somebody needs back surgery, that's different. They get a percentage man as a whole. Some people, because of their injuries, might be entitled to wage differential benefits until they're 67 years old. And that's 2/3 the difference between the wage they made on the date of their accident and then any other job that they may have to take because they have work restrictions and can't make as much. And we also have the ability to compensate for when there's been a fatal accident. There are benefits for that. Those benefits go up to $500,000 or 25 years of compensation. And we also have permanent and total disability benefits. And that's where someone cannot return to work either because they're completely physically disabled or because of their work limitations, educational background and work history. They're just not able to get back into the job market. And PTD benefits go on until somebody passes away.
What happens if someone doesn't notify their employer of an injury in a timely fashion?
Well, they have to give their employer notice within 45 days. And if they don't, that can cause problems later on, particularly if a defense attorney gets involved, because the act does require an employee to tell their employer within 45 days what happened to them on the job. So it's really important that employees tell their employer immediately what happened, and they should keep track of the date it happened. And ideally, they keep track of any employees around them who may have seen what happened. And they should also keep track of who they reported their accident to, so that later on, if the other side should dispute a workers' comp accident happened, they've got the proof that it did happen, and they have the proof as to who it was reported to.
Now, the delay in reporting, even if it's within the 45 days, that adds to credibility in terms of getting injured at work, does it not?
Right. Well, employers are looking for somebody to promptly report it. And when the person doesn't, employers being the way they are, everybody's trying to keep their financial exposure as low as possible. So employers and their defense attorneys will look wherever they can to dispute a case. So a delay in reporting an accident is not good to do. It's not an insurmountable obstacle to benefits, but ideally you go in and you tell your manager, your supervisor, or your HR department right away what happened and the day. It's very important that you report the specific date.
And isn't it true when they report it, that's very important to be very clear as to what happened, because if they leave something out, that can be used against them if the employer tries to argue that the injury is not related to work, correct?
Right. So if they fell on both knees, they should say, I fell on both knees, I fell on both knees, I fell on both hands. There was water on the floor. They should be very specific and as accurate as they can as to what happened. And then if an ambulance comes, if they can, they should give specifics to the paramedics. If they have to go to the ER or an immediate care center, the more detail they can give as to exactly where and what happened helps their case that much more if it's disputed.
Now, when you say disputed, does that mean a case is denied?
Yeah. If an employer accepts an accident as compensable, as actually a work accident that happened, that makes the employee eligible for the workers' compensation benefits, and they'll get paid presumably without any problems. But when an employer disagrees either that an accident happened or that the accident caused the medical condition, that's when you get the denials. And that's when an employee might have to litigate in order to get benefits under the Workers' Compensation Act.
Is there also oftentimes large disputes over what treatment is necessary?
Yes, because the employee will have his or her own treating doctor with their opinions, but under the Workers' Compensation Act, the employer can get a doctor of its own choosing to render an opinion. And then if that doctor says the employee can go back to work, when their treating doctor says the employee must continue to stay off work, that's when you start having disputes that may stop medical treatment, interrupt payment of TTD, etc.
Now, what if the case goes to trial or hearing before the arbitrator? Do they make a decision that day?
No, it takes a while. First of all, many times there are doctors' depositions because many times doctors don't agree on everything. The commission is a high volume entity. There's a lot of employment here in Illinois. There are a lot of work accidents. So it does take time until your case will go to trial. We have to do a pre-trial with the arbitrator and the opposing attorney to see if we can resolve it without litigation. If we have to go to litigation because we can't resolve it through settlement, that can take time till you have your trial date. Once you receive your arbitrator's trial award, either side can appeal to the commission, and almost every case is appealed. And when you're appealing and appearing before the commission, you're arguing in front of 3 commissioners who then have to issue their decision. Most cases stop at the commission level because the commission has such a great weight in deciding the facts and the law. But either side can then appeal from the Illinois Workers' Compensation Commission to the circuit court. And from there, they can appeal to the Illinois Appellate Court. Most cases don't go that far. In very rare instances, cases can even be argued in front of the Illinois Supreme Court, but you have to have permission from the Illinois Appellate Court. So a disputed case, if it's ongoing, can take a very long time.
So just like other types of cases, it's common to be asked, how long will it take to resolve? And what answer do you provide?
It's hard to say. Every case is different. Like all litigation, it's time consuming. It takes a lot of patience on an employee's part to wait until they might have a settlement or they might have a final commission award. So some cases can be resolved maybe within a year and a half. Many cases take longer than that. And the more complicated the case, the more disputed the case, the more denied the case, adds to the number of years that the employee is going to wait. But the commission does try and move things along as quickly as they can. And many cases do settle, although some do go to trial.
Now, what I understand, and perhaps you can clarify this, so to resolve a case, generally you're going to want the person to be at maximum medical improvement.
Yes.
And the treatment and the procedures can take over a year or 2 years sometimes. Is that fair?
Right. So you really won't be able to get a settlement, and you won't really be able to go to trial most of the time until the employee's reached maximum medical improvement. The doctors say there's nothing more we can do for the person. This is as good as it's going to be. And at that point, it's more likely that the case will be settled or proceed to hearing.
Have you had cases where someone could not go back to their prior job because of a disability from a work injury?
What they do when that happens?
Yeah, when you have a case like that, what happens?
Well, when somebody has a work accident and the injuries prohibit them from going back to their old employer, the employer just doesn't have a job anymore within their work restrictions, the employee is entitled to what we call vocational rehabilitation and maintenance. The vocational rehabilitation is to retrain them into a different segment of the labor market. The maintenance is the same as TTD. They're supposed to get maintenance or the weekly workers' compensation disability checks until they're placed in a new job.
Okay. So the employer has a duty then to try and help them find a job, and that duty may involve training?
Yes. And actually, the employer has the duty immediately once it's aware that the employee has work restrictions and they can't take them back with those restrictions. But an employee almost always has to ask for the voc rehab to make sure it's moving along as quickly as it should. And for those people that can't be placed back in the work, in any segment of the labor market, maybe it's because of their age, their work restrictions, their work history, limited education, or limited, computer skills, which you really do need today. Sometimes they're what we call an odd lot permanent and total disability. And then those people are entitled to workers' compensation benefits for the remainder of their lifetime. But not every case is a PTD. It's very kind of a strict standard. Most cases are more permanent partial disability cases, and then there are fewer that are wage differential or permanent total disability.
Part of it depends on the strength of the labor market at the time of the person's looking for work. Is that fair?
Yes, I would agree, because, in a good labor market, it doesn't take long for anybody to get back in. But when it's a slow labor market, that becomes a consideration, because the employee has to send out resumes and look for a job and keep a job search log. And if there's nothing out there, it builds their case to showing that they're possibly permanently and totally disabled and unable to resume work in any area of the labor market.
Now, when someone's owed benefits for the rest of their life because they're so severely injured, does that usually resolve in a lump sum, or does it resolve with the insurance company paying them for the rest of their life?
Usually it resolves through a lump sum settlement, because insurance companies don't usually like to maintain that kind of paperwork and record keeping. So a lot of times what is done is a present day value of the PTD benefits is done, and then both sides negotiate on what the actual lump sum amount should be. So a lot of those cases do get lump sum settled out. However, under the Workers' Compensation Act, an employer doesn't have to lump sum settle anything, because workers' compensation benefits are meant to be paid weekly by the employer. It's the employer's discretion as to whether or not it's going to issue a lump sum settlement, but it doesn't have to in any case.
So you have mentioned the term present day value. And it's my understanding that present day value means, so let's say the person has a life expectancy of 30 years, and they would collect collected, $1 million in benefits in that time frame. The present day value of that $1 million, though, may only be $250,000. Is that fair?
Yes, because we don't take every single payment for the next 30 years or whatever number of years. We look at it from the viewpoint of, how much does the insurance company have to have in reserves at a certain percentage interest in order to meet those payments for the next 30 years. So you're really looking at, in a present day value of a PTD, how much has to be invested now to be able to reach that ultimate number at the very end, if all those payments were made. But again, even on a present day value, there's a lot of going back and forth because, again, the employer doesn't have to do it if it doesn't want to. So there has to be a lot of negotiation and agreement on both sides until you reach that lump sum number for PTD benefits.
Now, let's say someone gets benefits for the rest of their life and the employer chooses not to lump them out, pay them weekly, and the person drops dead of a heart attack a year after the trial. What happens to the widow?
Well, if the heart attack is not related in any way to the workers' compensation accident, if it's not related, it's not related. And so the defense is going to argue that they're not on the hook anymore for benefits. If the employee's widow can show that the heart attack and the death were the result of the workers' compensation injury for whatever reason, then the wife would argue for the death benefits to be paid to her, because she will argue his death was related to the initial workers' comp accident. And those kind of cases are very much hinge on what the medical doctors say and what the written opinions of the medical doctors say. And the ultimate decision as to which doctor to believe is up to the Illinois Workers' Compensation Commission. It's not even really an arbitrator after a trial. It's really the determination of 3 commissioners during the appeal in front of the commission.
Now, let's say there's no minor children and the husband dies in a work-related injury and the wife remarries. Do the benefits continue to the wife after she remarries?
Now, that's a challenging question. I'm not sure I've had it before. So I'd have to look that one up under the Workers' Compensation Act. I'm very knowledgeable, but I do have limits to everything I know.
That's a trick question. The marriage actually nullifies the workers' compensation benefits. So the widow would have to remain single. It is the irony of the situation. So it's almost anti-family.
Right. I thought there might be a little window where they, but I could be wrong. But
this is why, lump sum settlements can be good rather than getting paid over time. So the employee or the widow may have an interest in settling on a lump sum because then the case is closed and they can remarry, or if somebody dies, there's not a consequence later. And money in hand in law can be worth more than money in bush. Is that fair?
Absolutely. If an employee's elderly, they're better off doing a lump sum settlement, because if it's not a death case, if it's just a PPD case, permanency case, if they pass away, nobody gets anything. So that's why a lump sum settlement is good, because you've got the money now and you're not taking the risk that something may happen to you later. So that's why many cases do settle.
Now, what if somebody's on Medicare? Does that change anything with respect to workers' comp?
Yes, because federal laws have to be followed. And under federal law, Medicare cannot pay for workers' compensation treatment. So if someone is on Medicare, or it looks like they're going to be on Medicare, we negotiate with the other side for what we call a Medicare set-aside account, which is we call it an MSA. And those are funds set aside separately to be used if when somebody's on Medicare and they need workers' comp treatment and Medicare says we're not going to pay for it, it's workers' comp. You have the MSA funds to tap so that you don't have any inability to pay for workers' compensation treatment while you're on Medicare.
Okay. So the lawyer has to take Medicare's interest into consideration.
Absolutely. Yes. Yes. That has to be done. Today it has to be done. And
yeah, I'm sorry. Ultimately, though, the client can say, I don't, they may say, well, I got cancer, I'm not going to live, so I just want to get the case over with. It's ultimately the client's decision, but the lawyer needs to advise. Is that fair?
yes, absolutely. Because if you're on Medicare and Medicare thinks you're getting workers' comp treatment, they're not going to cover the bill. And so that's why you have the Medicare set aside account. And if you go without an MSA, that will cause issues while you're on Medicare.
I see. And well, that's very helpful. Is there anything else you'd like to add, Mary Pat?
Well, I just want to say that it's very important, again, that if somebody's injured on the job, they tell their employer right away, that they keep notes on what's happening, how it happened, where it happened, if any other employees are around, who they gave notice to, where they treated. And they have to make sure they keep their attorney updated on all their medical information. They should get written medical notes if they have to be off work. They have to let their attorney know everywhere that they treated. If they get any unpaid bills or collection letters, they have to get them to their attorney right away. Because the more communication there is with the attorney and the other side, the employer, the more likely it is that the case will go more smoothly.
Thank you very much. And I appreciate you sharing your experience with the viewers. At this time, we're signing off from today. I'm in Palatine, Illinois, and we look forward to our next guest next week, and we will continue with this podcast, and we appreciate everyone's support. Thank you all.
Thank you.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.